Welcome, everyone, to the Center for Media Technology and Democracy's roundtable discussion on Part 3 of the Digital Charter Implementation Act, known formally as the Artificial Intelligence and Data Act, or AIDA, which is the acronym that I will likely be using interchangeably throughout this discussion. I am Supriya Dwivedi, the Director of Policy and Engagement here at the Center, and I will be your moderator for today's roundtable. Before I get to introducing the amazing panel of experts we've assembled for you here today, allow me to contextualize the scene here just a little bit. While the term artificial intelligence may have one thinking far into the future about Skynet-like technologies, the reality is that AI is in use and is all around us. Image and facial recognition, chatbots, voice assistants like Siri and Alexa, and even our largest telco provider, Bell, uses AI to monitor and block fraudulent calls. So, in other words, the future is already here, and AI is already a part of our everyday lives. And in many ways, Canada has been leading the AI charge. We were the first country in the world to adopt a national AI strategy. We're home to thousands of AI startups, and AI has the backing of public dollars, both at the provincial and federal level. And so it's unsurprising that Canada has become, a recognized global leader in developing AI technology, which is part of what makes, the newly tabled legislation so interesting. Because while we have one of the best ecosystems for developing and researching AI, we have arguably been lagging other comparable jurisdictions when it comes to the regulation of AI. And so with the federal government introducing AIDA in the House just last month, it became the first time that Canada set out a regulatory regime to expressly govern artificial intelligence. AIDA seeks to regulate international and interprovincial trade and commerce in AI systems by doing two things. First, establishing the common requirements that are applicable across the country for the design, development, and the use of those systems. And the second is to prohibit certain conduct in relation to AI systems that may result in serious harm to individuals or harm to their interests. One interesting thing to note off the bat here is that in its current iteration, AI systems used by Canadian federal departments or ministries, including those related to defense and national security, are excluded from AIDA. The legislation also has a specific framework for what it refers to as high impact AI systems, but what technologies are considered high impact aren't defined. And it's left to the individual or persons responsible for the AI system to determine whether or not the system is indeed high impact. And if the folks in charge of that AI system have determined it is high impact, then they must do the four following things: identify, assess, and mitigate risks of harm or biased output that could result from the system, establish ways to monitor harm mitigation measures and maintain a record of these safeguards, publish plain language description of the system, and lastly, to notify the government if the use of that system is likely to result in material harm. And there's two quick things to note here. Material harm isn't actually defined in the current draft and is likely to be defined in forthcoming regulations. And biased output here includes content generated by the system that adversely affects individuals based on what's set out in the Canadian Human Rights Act. AIDA also creates a new position that would be responsible for the administration and enforcement of the Act, known as the Artificial Intelligence and Data Commissioner. However, that commissioner would not be an independent agent of Parliament like the Privacy Commissioner is, and would instead be part of the Ministry of Innovation, Science, and Industry, with powers delegated to it by the minister. Not unsurprisingly, the lack of independence here has already started to raise some eyebrows. So with all that said, let's dive into the discussion about AIDA and get into some of those details. And for our audience today, there will be a Q&A portion at the end, so please feel free to put your questions just into the chat there in the Zoom function, and we'll get to as many as we can. So allow me to introduce our panelists for today. We have Ignacio Cofone, is the Canada Research Chair in Artificial Intelligence Law and Data Governance at McGill University. Phil Dawson is a technology and AI analyst who has spent around a decade as a senior policy advisor, including advisory roles to the UN as well as to the Government of Canada. Erica Eifel is an economist and journalist who founded Not in My Color, an equity and inclusion consultancy that builds inclusive workplaces. Emily Laidlaw is a lawyer and professor at the University of Calgary, whose work primarily focuses on cybersecurity, human rights, and the regulation of online communication technologies. Fenwick McKelvey is an assistant professor in information and communication technology policy in the Department of Communication Studies at Concordia University. And Christelle Tassono is a fellow at the Center for Information Technology Policy at Princeton University. Thank you all for being here. I wanted to sort of just jump right into things by having each of our panelists provide us with their initial sort of high-level thoughts on the act. And Phil, I'm going to pick on you first since I've known you the longest here. What are some of your key takeaways when it comes to the legislation as written?
Well, thanks, Supriya, and hi everyone. It's really great to be here with such a crew of panelists who I feel are going to really keep me on my toes from a number of sides. So some key takeaways for me when you're reading AIDA. First, the big takeaway for me is that this is actually a legislative framework for regulations. This is not the finished product of a completed regulatory environment. If you're looking at this as the government's last and only word on regulating AI, I think this would be an incorrect reading of the act. This is the beginning of the emergence of a regulatory system. So we have some high-level obligations that will be operationalized by regulations. Well, I'm sure we'll get into some of those and what we think about them. The second thing, two more takeaways. There's, I think, is still a strong signal to businesses to begin implementing risk management practices, particularly for harms, as those are defined, both to individuals and some of the and in particular protected groups that are referenced in the definitions of both harms and biased outputs. And so there's a benchmark of good practice that the Act intends to instill, and some of this will be elaborated in regulations. The last thing that is a key takeaway for me is that the maturation of this regulatory regime will likely depend on the emergence in parallel of an AI assurance ecosystem, or a market for AI assurance services, assessment, audit, maybe even conformity assessment services. These are things that are being discussed in other jurisdictions, for instance, in the EU with the Artificial Intelligence Act that was proposed just over a year ago. The UK, which hasn't come out with regulations yet, but has signaled that they will have a white paper on AI regulation sometime in 2022, is also forecasting this approach, and the US is beginning to develop some priority industry standards, which would similarly fit within this approach. So, looking at AIDA, there's some interesting provisions in audit. And to me, that's an assessment of high impact, high impact systems, and however they end up being defined, and the methodology for defining them. Assessment and audit and conformity assessment will be a key piece of this legislation as it evolves, maybe in Parliament, and then certainly under discussions for forthcoming regulations. So those are some three key takeaways for me.
Ignacio, I saw you nodding your head quite a bit there. You want to get in on it?
Oh, well, Scott. Yeah, I mean, I agree with Phil in what he says. My short take would be that, well, first of all, this is, even if it's not perfect, it's one of the better acts that I've read, I think, trying to regulate AI. Depending on how the details end up working out, I think it's actually quite good. I think one of the better things about it is that it regulates on a risk-based approach that closely relates to the privacy portion of the proposed act without being redundant with it. And it has potentially, depending on the powers that the commissioners are having, actual fines. The bad is that it in some way inherits some of the weaknesses of our privacy framework that is replicated in the CPPA. So while there are good things, such as the risk-based approach that doesn't, for example, make the act fully dependent on consent, like the privacy provisions are. So the privacy provisions basically rely on individuals not consenting to the things that are bad for them, and then exercising the right so that they're effective. The risk-based approach of this act doesn't do that much, and that's great. I also think it's good that it has an implicit acknowledgement in some parts of it that AI is already regulated by different branches of law. And the idea here is to provide a general framework that would lead to other regulations and not to override, for example, product liability or other areas of the law that actually are relevant to any use of AI. I think the main downside that comes from this is that there's some ambivalence in the act about whether we're regulating a technology or different use of the technology. The act seems to focus on regulating a technology, but the right approach is not to say that a specific technology needs to be regulated, but different uses do. The CVPA by contrast talks about automatic decision making, which is one of the riskier uses of AI. And I understand that the aim of this act is to interact with that one and to be broader, because not only automated decision making could be harmful to individuals based on AI, but it would be good to see a more robust effort of, okay, what are the uses of this particular technology that warrant a different type of regulation, because it's not just that things that are done in machine learning are bad and we don't do them with machine learning, they're good in ways that they should just jump in and out of the framework. It would be good to see, at least for the parts that are not entirely risk-based, a more robust liability regime. Because the reality is that whenever laws are enacted, and particularly if we're trying to make them technology-based like this one does, it is impossible to anticipate all the risks and harms that may happen. And to have some sort of liability regime would allow us to catch the things that our anticipation didn't exactly predict, which is something that we probably won't see because we also have that problem in the CPPA. But overall, I think it's depending on how different things fall, such as what is the definition of anonymity, exactly what powers will be had in terms of enforcement. I think, as Phil said, it's a first step in regulating AI that is overall quite positive.
Erica, let's get you in on this now. I mean, I'm guessing there's going to be some cold water poured on some of the optimism and positivity here.
That's what I'm here for.
Yeah.
This bill scares me, I will be honest. As somebody who is BIPOC, a Black woman specifically, we know the problems with AI in terms of, especially facial recognition, in terms of identifying dark people. And dark is relative, right? And so the propensity for misidentification is quite high when it comes to Black, Indigenous, and people of color, non-binary people, trans people, and even sometimes women. It's not the first person who was killed by a driverless car was a woman. So I think we really need to step back and look at what harm means. Harm is not individual. These harms are not a sum of individual parts. These harms are systemic and they're systematic, and they have the propensity to deepen the discriminatory regimes we have now at scale. And the fact that this hasn't really come up is troubling to me, because this is well known. If you look at Georgetown surveillance studies, Queen's surveillance studies, it's pretty much a huge topic of discussion, not an afterthought. So to say that this is only the first crack at the bill and they'll get it right later doesn't give me comfort. And especially as somebody who has worked in the federal public service for about 13 years at both Treasury Board and the Department of Finance, what was supposed to catch this was the gender-based analysis plus, which I would love to see because it didn't do its job on this. Secondly, for me, if any of this regime harmed me, I have then to report to the federal government, to the minister. Well, who knows who the minister is going to be in 5-10 years? Who knows how open they will be? The fact that the oversight is not independent is troubling. The fact that the person who will regulate this comes from the public service themselves is troubling, because I don't know if you know much about how the public service works, but it's not exactly fair in terms of how it promotes people. And therefore, the senior management of the public service being responsible for this is not on. It is not on for the marginalized people who are discriminated against in this country already. And on top of that, like law enforcement being exempt, border services being exempt, any company who creates a product or service having to do with AI for any one of these agencies is also exempt. So this to me is a big, big issue that I find that there's been a lot of silence on.
Emily, let's bring you in. You were nodding quite profusely there as Erica was talking.
Yeah, no, I was nodding along because I agree with Erica's take. I think she was making some really key points, and you know, I do acknowledge that this is, you know, it is a first step, but because of some of the other deficiencies, it's not sufficient as a first step, right? It needs to be drastically, I think, broadened and some of the provisions deepened. I do like the risk management framework. I think that's the way to go. I think it's consistent with some of the other movement that we're seeing in areas like online harm. But what it isn't accompanied by are some of the critical features we need in law to make risk management system work. One is that we can't just leave it to the companies to make their assessment of what's high risk and make their assessment of that risk management and then follow through with that. Even, you know, maybe, you know, they might be selecting their own auditors. I mean, it was unclear in the way the legislation is written, or they might be, you know, they're doing their own impact assessments and publishing that. But it also then needs to be accompanied by a strong third independent regulator. And none of that is featured here. I am actually really surprised and confused. Why would they select to have some commissioner that reports to the minister that really has no powers and is just folded within a government entity to do this critical job, especially when they're leaving so much to be decided later? I think that to be able to evolve with technologies, you need some sort of independent regulator like the privacy commissioner, but with powers if that ends up coming, you know, if that ends up, you know, happening, that also, you know, has some sort of you know, ability to issue fines that can work with these companies. None of that exists in the way that this is written. And we need a regulator that can write codes of practice that kind of evolve over time with what the changing technology is, right? If we're not going to put a lot in legislation, then you develop more through regulations and then through codes of practice. The way it's structured doesn't enable that. And I was thinking through, you know, the focus on a harm-based approach here. I thought it interesting that it kind of uncouples harm from bias output, because I saw that as an example of harm. And I thought that a missing key, it was strange to me. I thought a really important feature here is that the obligation is not just related to harm, but is also to human rights, which are linked, right? But that the obligation of developing these systems is to have an eye to what are the potential harms that are, you know, here, and not just the development, but the use of AI by companies. So you've got a few different players in the system, right? But it is human rights as in protection from non-discrimination, protection from protection for equality, for privacy, for due process. How about the right to life? Like, all of these are really key features that need to be imprinted into this legislation, and it needs to be at the forefront. And then what flows from it, I think, can be better through regulations and codes of practice. So maybe I'll just leave it there, and then we'll get into the weeds in a little bit.
So, Christelle, let's bring you in, and then we'll go to Ben to round us out.
Thank you so much for inviting me to be part of this panel. I really agree with what my co-panelists are saying. And to sort of boil down my three main problems with AIDA, first, I think that I agree with what Emily and Erica are saying, that like there's a lack of independent regulatory oversight. I'm afraid that it is deemed an afterthought in this regulation as written. And I think that is a really big problem, because when you under-resource one agent to report to the minister, then there's not a lot of opportunity to be very critical of how the ministry makes regulation and decides to enforce the law itself. And then my second point is about the lack of provisions related to biometric information. It may not be like only in AIDA, but also like in Bill C-27 that it should have been included. I think it's very dangerous to not include the types of information and how they should or should not be used by industry. And this leads to my third point, the absence of public sector regulation related to AI. I think it's very dangerous. We've learned with the case of Clearview AI, how unfortunately agencies, specifically law enforcement, tend to procure these products and use them in ways that are very obscure. So these are like my three main problems. I have other issues, but I think I'll let other people speak, and then more questions can begin on that point. Thank you.
Sure, Ben, let's hear from you next. I mean, and one thing would be great is if you could put this bill into sort of the broader discussion of AI regulation.
Yeah, thank you. And that's, I think, one of the things I wanted to start off with was pushing back a little bit on this being a first step, because I think that it really underplays the amount of commitments that have been happening on AI governance and regulation in Canada. I think dating back to the Pan-Canadian AI strategy, which I think really deliberately concentrated resources in a few centers and clusters with a very narrow research mandate. And I think that part of what we want to try to understand is the consequences of that decision on our present expertise to talk about what is good AI policy and good AI governance. And I think that this is something that, we can try to look at how this bill fits into a variety of initiatives that are taking place, including my own work at the CRTC's unwillingness to kind of acknowledge, deal with artificial intelligence. I think to a point that I see both Elizabeth and Erica raised about the track record of these assessment-based tools. Algorithmic impact assessments have been something that,
just FYI, yeah.
Oh,
you said Elizabeth, yeah.
No, in the chat.
Oh, okay, sorry. Yeah, continue. Yeah.
No, I'm multitasking here.
Yeah. You're doing it all. You're doing it all.
I'm in this Zoom game deep by this far in the pandemic. And so all I say is that I was going to, one of the things to me is that a lot of those assessment tools haven't necessarily proven to be that effective. And I would love to hear more about, Erica talking about GVA+, but, particularly how we think about assessments and what does that assessment regime look like is something that we should be building on kind of existing, past failures and past successes about that. And the last thing, kind of in this terms of context is this is also happening just at the Toronto Police Service Board has passed its policy about AI. And I would say that that consultation came out before the release of its race-based data. So one of the things that really I think is important is that a lot of these concerns to put the onus on institutions themselves, many of these institutions, particularly the Toronto Police Services, and I'd also speak to myself and Joe Jogge or Montreal, these institutions have histories of systemic racism. And how are these going to be effective environments for learning machines? And I think that that's one of the parts that gets at Ignacio's comment of where we're regulating and how is there an onus on these institutions themselves to actually create the conditions to allow for effective artificial intelligence. I think that that's something that's unsettling. And I think the fact that we've seen a lot of movement and how this bill is going to relate to then the Toronto Police Services and its own use of artificial intelligence remains to be seen. The two other kind of key points I'd like to make is that, one, I think there's a benefit here about acknowledging clearly a data power issue. And I'll put a link in the chat here to a great award-winning report by two of my MA students, Nick Kurtler and Megan Wester, who really talk about the consequences and the limitations of the last Privacy Act and this de-identification regime, which really allowed for all these kind of problematic uses of technology because the data was de-identified. So I'm encouraged that we're seeing a first step to acknowledge data power as something that is a problem in and of itself. And so, I mean, I think in Erica's comments about talking about systemic harms, I think data power is closely related to that kind of question that we're at work here. And I think the last thing that I think increasingly concerned about is the rhetoric of participation or working things out that's embedded in many of these bills, and this kind of delegation of where the work's going to take place. I'm particularly concerned, as I said, about like where the institutional contexts that are going to be doing these self-assessments, and do they have the capacity or willingness or ability of doing so? Are they actually collecting the types of data that could say that they are encountering or perpetuating certain forms of biased outputs in the language of text? And then I think also the language of participation, as it assumes that there's a public that's capable and willing to participate in this. And I think often the language of participation presently in a lot of our bills and consultation, I think stands in the ways of building actually good democratic governance, because civil society organizations, community organizations don't have the capacity to participate, I think, effectively in the nuanced work that it takes to articulate these bills. And that's one of the things that I'd be concerned about when we talk about an early draft, but whether and where we're going to see those voices included in the process.
Yeah, I mean, that leads me pretty well into the next question, and I'll throw this out to the group, and whoever wants to chime in first is welcome to. But one of the things that struck me about the introduction of AIDA in particular is that everyone was sort of expecting a privacy overhaul bill simply because the government had introduced it in the last iteration of Parliament, and it ended up dying on the order paper. So everyone sort of knew something was coming. AIDA, though, in particular, seemed to take a lot of folks that are normally in the know by surprise. And so I'm wondering, in terms of the group here, are you worried about the lack of consultation that was sort of, Erica, there you go. Let's get into it. Go first. Yeah.
Well, what I don't understand is a couple of days after this bill was tabled, the Ethics Commission released their own report on AI. And so it seems like nobody was consulted. Where are these consultations, and who did they consult, and what were the results of those consultations? And so if this is kind of done under the table, introduced at the last stage, I have questions about why they want to just slip this through while the uproar of Bill C-11 is happening. I'm just suspicious of government. I know how the sausage is made, okay? So I'm just suspicious of timing. And it just seems, I don't know if they really want much, consultation on this, because like I said, I don't know of people they've consulted. I would like a list, to be honest, and I would like to see those made public. And the GBA plus assessment should be made public, to be honest, because the whole point of gender-based analysis plus is to catch these things, is to say, well, we know that AI can produce systemic discriminatory outcomes against X, Y, and Z. That is part of the process. Where is that?
Christelle, you've got your hand up.
I really agree with what Erica is saying. To add on to that, I remember very well during the press conference about Bill C-27, Minister of Justice, Minister Lametti, said that provisions related to the Privacy Act are coming. They're working on them, and they're going to do it in conjunction to amendments to Bill C-27. And I wonder, why are those two things happening distinctively, and why was not this included as part of this legislation as well? And it just feels like there's a lack of clarity, again, as to what Erica is saying about who has been consulted, how consultations are happening. It's deeply concerning, yeah.
In terms of one thing that Ignacio, you had touched on in your comments with respect to liability regimes, one thing that's worth pointing out for the group here is that you actually authored the Office of the Privacy Commissioner's report regarding the reform of Canada's privacy statute last year. And one thing that was highlighted was, needed improvement and more flexible enforcement mechanism that allows Canadians to sort of seek individual redress if need be. In terms of how AIDA is written right now, do you think there are adequate enforcement measures sort of in place for Canadians who have then had their rights, violated and need somewhere to take, to seek sort of redress there?
No.
Okay.
So that's first of all an example of what folks were saying of lack of consultation, right? Also for the Privacy Act, the OPC did this enormous consultation. It had a bunch of experts sending. Then I worked with them in developing the report. They had comments from experts and from the public that they took very seriously. And then Parliament came in with this absolutely different bill that they did not work with the OPC for. So it is not only for the AI Act that there was like a consultation, but also for the privacy aspect, just because the whole constitution done by the OPC was in a different lane. And I think they both have the same problem in that relates to Emily's point on okay, what kind of enforcement are we seeing here from someone who depends on the ministry? I still think that someone that can enforce fines under the ministry is better than that tribunal that they came up with for the privacy part that has some experts, some non-experts. You don't know what they will do. So I mean,
then you don't know government. I will just say that. No, when I say you don't know government, if you think that that's better, then I don't think you realize how little you have to understand that these analysts, these people who do this work, the people who are drafting these things aren't experts, right? They're not like the people on this panel here. They are analysts that have worked here, there, everywhere. Maybe they worked at Health Canada, maybe they worked there. So the fact is that you're getting people who do not have the expertise either, who have a conflict of interest, I would say. If you are a bureaucrat and you want a promotion, you're going to do what the minister says, right? Your job is to implement to give impartial advice, but to implement what the government wants. That is your job. So when I say there's no oversight, there's none.
Right. Yeah. I mean, without going on a tangent of which of two bad options is worse, what I was trying to say is that's why liability is so important, because whether it's someone depending on the ministry, whether it's the OPC, whether it's a tribunal with some experts and some non-experts that we don't know what they will do, none of them will be able to catch all wrongs, and none of them will be able to catch all harms. So having individuals be able to seek redress, and not only as Sarika was saying, complain and maybe have their things followed and maybe not have their things followed, I think it's crucially important for the protection of people's rights under this act or under the Privacy Act. And none of them reflect that in their current form.
Yeah, Emily, go ahead.
I was just going to jump in because, Ignacio, I absolutely agree that recourse is necessary and it's missing here. And I kept flipping back through the act going, it's got to be here, like some avenue, but it was not. And I mean, in an ideal world, if we could just like wave a magic wand, we would really be taking the advice that had been given in the last iteration of the Privacy Act. I always get confused between the California one and our Canadian one.
Yeah, they didn't pick the best acronym for that one. AIDA is an okay acronym. CPA is like, okay.
Yeah. And but it would be not that. I don't see why they aren't putting this under the house of the Privacy Commissioner, because there's just such a strong connection. And I mean, the Privacy Commissioner's office might say, "Oh my God, we're under resourced and have too much to do as it is." But ideally, there would be no tribunal, and this would be the independent Privacy Commissioner that would have the power to investigate and impose fines.
Phil, let's bring you into this discussion, because I mean, you've got a really interesting vantage point in terms of you've been on the academic side of things, the policy side of things, as well as on the industry side of things. And you touched on this a little bit in terms of your opening remarks, but getting to the regulations, because it seems like a lot of this is like dependent on what these regs end up actually looking like. So in terms of your own vantage point, I mean, what would you like to see the regulations really touch on that emerge from the Act?
Yeah, thanks, Supriya. It's, really great, interesting discussion. I really hope that that a lot of this will be picked up in consultations on future regulations, because I think in some ways one of the things we're debating here is a choice about what needs to go in an act and what needs to go in the regulations. And I think maybe there's some adjustments to make in the act, but maybe some things we're discussing are more appropriately situated in regulations, which can be adapted a little more easily, not perfect and without pitfalls, but certainly more agile. And I'll just expand a little bit on what I mean there. I think if you look at the EU AI Act, which I think has some really great content. It's also about 80 pages. The act was tabled just over a year ago, and since entering committee, it has received over 3,000 proposed amendments. Some of this is due to new knowledge about the potential capabilities of general purpose systems. Some of it is about a lack of consensus on how to define AI. Some of it is about the appropriate way to classify AI, high impact AI systems, whether in a kind of an Annex 3 laundry list of systems organized by intended purpose, which may or may not be very appropriate for general purpose systems as those continue to evolve. And I think for us in Canada, I think we have to look at this other types of regulatory models. We really only have this one. There's the Algorithmic Accountability Act that has been proposed in the US. Most people you will talk to will tell you that this is absolutely no chance of becoming a law. So to me, there is one really viable model that is out there. And part of the choice that we have, I think, is to say, are we equipped, or is it even desirable to have so much detail for a nascent technology in an act of parliament? And if we've been reflecting a little bit on pivotal reform and the 5 or 6 or 10 years that this has been discussed, is still not passed yet, right? So we've lived in a context of minority governments. We see bills die in the order paper. If we're planning ahead for a resilient and more future-proof system, I'm not saying that we shouldn't be adding more into the act as it currently is phrased. I'm just saying we have to be conscious of this dynamic in designing the future and long-lasting regulatory environment. So on that note, like some of the regulations that I think are maybe fruitful, some of them are listed in the act. Fruitful places to capture some of the, if not in the direct provisions of the act, if we look at, for instance, the assessment for high impact systems, just a plain reading of this provision says that this should be done by the person responsible in accordance with the regulations. To me, just reading that leaves room for some type of conformity assessment that is done by an independent body that is accredited, that has to follow certain criteria. So there's still quite a bit of room for that type of legitimacy and credibility that we want to see in how companies define systems. That's just an example. So I think that's a priority in terms of regulations. I think probably all the ones contemplated will have to be issued to operationalize this act. That's a key one. I think to see more criteria on risk management to operationalize that's I think Section 8. And you can look at some ideas, some good ideas for how this might happen. You might look into the EU AI Act, and we might come up with some criteria that looks quite similar, or maybe even more, I don't want to say onerous, or more robust, or you name it. And I think a key, I'll end there. I see Fenwick's hand up, and I'm sure people will want to jump in. But something that we should also pay attention to, and I think another kind of policy instrument that's going to be very key, not just in Canada but internationally, and will help secure interoperability, market access, and trade, is the use of industry standards and conformity assessments. And you know, there's a lot to be done in terms of policy programs to ensure that those remain democratic, open, accessible. There's a lot of work to do there. But those are some of the key tools that other jurisdictions are using to drive compliance and trade, and also to bring some level of credibility and even, you know, community-based standards through certification programs. I'll just mention the Responsible AI Institute. I'm an advisor of the Responsible AI Institute. They're developing a community-sourced, independent AI certification framework. And this could be one of the key pathways to compliance, but also best practice and greater democratic legitimacy from a soft law perspective. I'll just end there.
Ben, let's get you in. I saw you put your hand up, and we'll note you didn't actually use the Zoom hand function, but that's okay.
Yeah, yeah. And I forgot to unmute myself. So all those fun. What you know, one of the things I'd often say is I often hear in Canada describe Canada's benefit as being a last mover, in the sense that it can hear from other countries and adapt and adjust. And I see in some ways a lot of that being reflected in this bill, where you're seeing clearly at least some of the stakes and the grade coming from the AI bill in the EU and the Accountability Act. I think the two worries and the kind of, I think, parts where there could have been a clear opportunity and missed opportunities. One, in the American AI Act, it talks about having 50 jobs dedicated to enforcement. And so clear a link between who's actually going to be implementing and doing this work. And I think the vagueness about it's going to be another commissioner and what are those commissioners looks like, I think demonstrates it in one sense, a concern about, you know, whether we've learned enough about the capacity of implementing this. That's something that was also the criticism of the EU bill about who is actually going to be doing this kind of auditing. I think the second part, and what I'd say is that, you know, it's interesting seeing the beginnings of a formation of an industry about responsible for auditing and assessment. And I think that that's something to be kind of mindful about, is where are we going to be building these systems of expertise? And, you know, one of the things that, you know, I've learned is that part of the way that we're dealing with these harms of systems is dealing and listening to those who are affected, not necessarily the experts who are, you know, triaging what harm comes. And what I worry is that in delegating and thinking about setting up an industry that will be responsible for this kind of conduct, is that it'll lead to a further marginalization of the voices that are being affected by this, and without the resources necessary themselves to participate. And that's another, I think, known issue with a lot of our governance structures in Canada, is there's this presumption about the ability of participating, and those systems are deeply inequitable who and can participate. So I think it's one thing that you know, is important for us as bill goes forward, is to really think about what it would mean to have meaningful civil society engagement and meaningful engagement from the communities themselves that have expertise in how these algorithmic systems are creating harms, and creating, I think, a different rubric and language of what we do when we talk about assessment that's not simply risk-based assessments.
So let's bring you in now, because I mean, you submitted testimony to the Standing Committee on Access to Information, Privacy and Ethics, outlining the case for a ban on facial recognition technology by law enforcement. If the government does indeed, you know, move forward without a clear ban on the use of facial recognition, I mean, what are some of the steps they should be taking in order to minimize the potential harm here?
Yeah, that's a really good question. And I can summarize that in like 3 points. First, it means better procurement practices. So an example of that could be banning the procurement of technologies, of these types of technologies, by police agencies, or, you know, finding ways to make it more clear and restricted. Second of all, there should be restricted usages by public and private sector on facial recognition technology, and like broadly also encompass biometric information technologies. And then that leads me to my third point. We need a dedicated legislative framework addressing the use of biometric information, and that can be included in a Privacy Act, for example. I can go more in detail as to like how that can look like, but just to be like very succinct, going back to like public sector usages, like for example, in Massachusetts, this means not every police officer or agent in a specific agency can have access to the technology itself. Like only high level with a specific clearance can have access to the technology. There are also warrants that can be made in order to allow the use of that technology. Like there are different steps that can be taken in order to limit, but fundamentally, I think that the problem is about how communities are over-policed and how these technologies don't actually solve the issues. They're just a tool of surveillance that is deeply disconnected with demands that have like been made for decades. In Montreal, we've seen over the past 2 years, defund SPVM clearly outlining that we need a reallocation of police funding towards services. We don't need more technology that is deeply invasive. And I think an example of that is how in a park in Saint-Michel, actually there are 5 parks in Montreal, but notably the one I grew up next to, they've installed CCTV cameras in the park where children, elders are playing. This makes no sense, and the community was not consulted in any way about how they want greater safety in the neighborhood. Just this fundamental detachment with community and technological innovation, like it needs to be addressed in addition to what I've outlined before.
Can I just
Of course, yeah.
add on that, on what Christelle said? ProPublica did a wonderful investigation about predictive policing. And predictive policing is one of the scarier parts. Like they're using AI technologies to predict who's going to be a criminal. And lo and behold, of course, Black, Hispanic, and of course, Native American people were more likely to receive higher fines, higher sentences, arrests, all of the things. And so I don't know, to say, in my opinion, to say we don't know the harms of this or what the potential harms of this would be is wrong. It's incorrect. We also haven't talked about mass surveillance and how this bill, how does it address mass surveillance? Does it address mass surveillance? I would say no, it doesn't. And that's another huge issue that's on the horizon right now. Right now, it's being applied to people who in society, our society doesn't really care about, I'll be honest. So Christelle brought up biometric data, which is being used on asylum seekers, right? And so I think to prove nationality, which is beyond me, but anyway, that doesn't make sense to me, but whatever. So I think the fact is that these technologies are already present and we already know the harms they can cause because they're causing them already. The fact that I said, or whoever I said, didn't bother to look at it and didn't bother to implement that in the bill is a failure of government. It is not just something that will fix later, because there's no guarantee that this will be revisited later and fixed later, especially as I think Philip said, or sorry, maybe it was Ignacio, I'm sorry, who said that we're in successive minority governments now. Well, what if we get a far right government?
Yeah, that was Phil. Yeah.
Don't like, it's very likely that that will happen sometime in the future. And it goes back to the lack of independent oversight. And it goes back to the fact that we're a democracy. We're supposed to have checks and balances where the accountability is not good enough. And the fact that law enforcement agencies, CSIS, can use these at will. We're also part of Five Eyes. And given what's happening in the States with abortion and surveillance and abortion apps and that surveillance technology and the propensity of Americans coming over the border to access those services, this becomes more than just a Canadian issue. It becomes an issue of who gets caught in this regime. And if I can imagine that at this point, me, and I'm not the one who has access to all of these different reports and people and stuff. If I can see that, why can't the people who came up with this bill and the government see it?
Emily, I saw you nodding along there. Is there anything that you wanted to add, or was it just like an amen to everything Erica was saying?
Yeah, well, I've had my hand up because there's so many points to add on to, and I think that Erica sort of brings that home, which, and I want to draw back to Philip saying, look, this is supposed to be almost just structuring what is then detailed later in regulations. And I do absolutely agree with that. I think that is the structure that we need for flexibility later, but we need something vastly different set out. But the legislation itself has to actually set out what the structure is. And this doesn't. And so bringing it back to Erica's point, what we see missing is that this regulation is really not the regulation, but the legislation is looking to ways that it can create these industry standards, which are key. It's looking to prompt better self-regulation by these companies. Very important. And we want that. And we want it to be done in a way that's consistent with a lot of the developments we're seeing elsewhere, like with the EU, because really this is global, right? But ultimately, there also are some profound harms related to AI, which requires then in the legislation to set out a much stronger role of government and accountability. Now, it seems like there might be some power that could be taken up by the minister, that could be set out in the regulations, but the fact that acknowledgement and the structuring of it in that legislation is necessary to say there are certain, uses of AI that would be seen as profoundly harmful, or say certain uses of AI that, in say critical infrastructure that require much stronger government oversight. And I don't see that in the way that legislation is set out. And then if we look at then the full circle of it, we've been talking a lot about individual and collective harm and the need for recourse. That would be the full circle of what is necessary for proper AI oversight. That also needs to be set out in the legislation. So I think I'd love to see them take this away and flesh out so it's fully covered, these different angles on, and it's not at that point. Right now, it's very much focused on industry standards and corporate self-regulation.
Emily, let me stick with you for just a second here, because you're also co-chairing the federal government's expert advisory committee on online safety. And so I was just wondering if you thought there was an inherent tension in the way AIDA is sort of going forward with a bit of a harms-based approach, given the fact that it's likely the online safety bill that the government will eventually propose, I'm guessing sometimes in the fall, is likely to adopt a duty to act responsibly. Is there, are those two in conflict? Is there a reason why that is? I'm just wondering what your take is on that.
Yeah, so in some ways they align what the proposals are here, because, and I know Taylor Owen's listening in, and we were on the panel together, and this focus on due diligence or risk management that we're seeing with the AI Act is very much what we were working through as a panel. And so I think there's going to be a lot of alignment that there will be ultimately online services would have a duty to manage the risks of harm of their various services. But one of the reasons that I mentioned human rights today is that the panel, the consistent feedback was, yes, a risk management approach, a duty to act responsibly is the right way to go, but it is not just that duty to manage the risks of harm. It is also a duty to respect, to protect human rights. and that both obligations are going to have to exist simultaneously. And so I really hope that the government takes that to heart and puts that in the online safety bill that they ultimately propose. And I would love to see that consistently across the board with these various kind of digital bills that we're seeing proposed, so that there could be some sort of alignment. But you can imagine here where there would be obligations under AIDA in terms of the use of AI systems. And I suppose there would be then risks of some sort of investigation and some sort of audit by a commissioner that would be working under the minister. But what, if they go in the direction that the panel seemed to be really pushing, was that there needed to be some independent regulator like a privacy commissioner that actually addresses online safety and that has that power to investigate. So there could potentially be simultaneous investigations, but that might be necessary because online safety would be broader, right? It wouldn't just be about AI systems that might be used by the online services. It might be other aspects of it. Ultimately, what we're seeing is we need the different commissioners to be connected and in conversation and sort of figuring out what their roles are. But that's the complex space that we're in. That is the reality we're in. And I don't see that as necessarily problematic as long as they've really thought that through.
Fenwick, in April of last year, you wrote an op-ed for the Globe and Mail kind of pointing out a bit of the discrepancy, I suppose, between Canada's enthusiasm for pumping money into AI alongside the lack of, kind of what we're talking about here in terms of a robust rights-based approach to AI governance. In the last line of the piece, you and your co-author state that by continuing to fund AI without developing better governance of it, Canada is letting the industry write its own rules. Well, now we've got AIDA. I mean, does the bill assuage any of those concerns that you and your co-author posed in the op-ed last year?
So I think what we're responding to is the launch of the EU's AI bill. In that sense, I think a need for meaningful AI governance, talking about the risks and the harm reductions, has been a long time coming. And I think that if Canada I think one of the deeper frustrations that Canada's long branded itself as an AI for good, and yet none of that AI for good necessarily has translated into a tangible policy agenda. And I think Ignacio can talk about the responsible AI consultation of the privacy commissioner and where that went or didn't go as a kind of think a cause for concern about where are we talking about these institutions and how does that consultation lead into something that actually has teeth and effectiveness. The part for me is I think I think I'm slightly ambivalent about this bill. I see directions of where this is important, particularly to build on Emily's points, the ability of sharing data between the privacy commissioner, the data commissioner and AI commissioner here, and the CRTC is speaking to these opportunities for coordination as a first step. I also think that the commissioner's ability of engaging in a public education role is an important part of trying to actually foster this conversation further and trying to actually say that the way we understand AI is fraught in a number of different ways, from killer robots to, I think, being benign. The challenge, I think, is that really what's happened is that we're dealing with after Clearview AI, and a lot of investment in AI as a regulatory and a governance tool quite directly whether that's in hiring decisions or many of these different places. I think the challenge now is that for lack of a better metaphor, the horse is kind of out of the barn. A lot of this AI is being used actively and presently, and how do you see a way of catching up to the ways that we encounter AI in the world today, and whether we have enough resources and capacity of this bill presently to really adapt to the harms that might be facing, people in Toronto, folks in Toronto who are dealing with the police services using AI in a police force with a history of systemic racism. Like, where are the ways that we're catching up to those kind of known concerns presently? And in the years since I've written that article, I've learned a lot more about just the way in the context of where AI is being used. And is that necessarily the bill working with that kind of baseline knowledge presently?
I'm cognizant of the time here. We've got a bunch of questions that I do want to get to, but Ignacio, I just wanted to bring you in to see if you had any sort of last comments before we moved on to questions based on what Fenwick just said.
Not really. I think I think actually Fenwick, Emily, and Erica have been framing the issues really well. No, I'm happy to just move to questions.
Okay, great. So got a lot of them here. This first one is, does it bother anyone that the regulation is cut off completely, it seems, from government use of AI? People complain that the privacy regulations are disjointed that way, and to have this perpetuated is odd. Whoever wants to take that.
I have a really boring lawyerly answer, which is that federalism might be the reason. Emily knows much more about this than I do, but the federal government only has some powers to regulate state uses that are provincial, and keeping it private and public sector separate, like with the privacy system, allows to be constitutional. That said, this could extend to federal government agencies. I don't see why not, and it would be good to have either a twin version of the act, like there is with the Privacy Act, or directly a direct extension to use of AI by the federal government. Unfortunately, there's only so much the federal government can do to also cover important provincial uses.
Emily, does that sound about right from your perspective as well?
Yeah, you know, I
boring lawyerly answer. Yeah,
boring lawyerly answer, but he was absolutely right. I thought it was really interesting. He's right. Yeah, I agree with you, and I think that federalism is increasingly, you know, as someone who's sitting here in Alberta, our government is really feels tense about federalism, and so I think that there'd be a real struggle to try to extend this to the public sector and to government, unless they're really just focusing on the federal sector, which would be really interesting, because then you would end up with, like, you know, the RCMP falling under, you know, the rubric of this, but not, like, you know, municipal police agencies. But hopefully what we would see is what we saw with some of the other privacy legislation, which is it did set the blueprint and had this ripple effect. I 100% agree that I would love to see this as apply to at least the federal government.
Phil, this next question I think is best posed to you, just in terms of all the many hats that you tend to wear. To what degree is this legislation applicable for companies developing AI in Canada versus AI developed elsewhere, but applied / used with Canadians?
Okay, I think I'll answer the first part. Maybe somebody has a better answer than me. Maybe one of the lawyers here can hazard a guess to the second part. But the first part, yeah, it's a good question. The Act purports to regulate AI that is used interprovincially or intra-provincially, so across provincial borders or internationally. I would say that will probably capture all, or should capture, AI, let's say, vendors, manufacturers that are situated in Canada, simply because for practical reasons, I'm not aware of aspiring startups or companies that hope to only sell within, you know, their municipality or within their province. So I think there is going to be a lot of businesses, if you're in the AI industry, you are going to by default have to comply with the rules. And look, this is not a very, maybe a sophisticated legal interpretation, but that's kind of my practical perspective here. That the AI ecosystem, the AI industry in Canada will be captured by this act, because they intend to sell outside their province and internationally. And frankly, if they don't do that, you know, they may not be a viable business, just the Canadian market being what it is in the global digital economy. And then maybe I'll leave it to somebody else to answer the last part about how this regulates AI systems being sold into Canada. But you know, I think that some of the same principles apply. It's one, you know, those are systems that are entering Canada through international trade. So to me, they'd be captured.
Either Emily or Ignacio, if you wanted to add to that. Good. Okay. Moving on, this is a question about algorithmic impact assessments. Does this new regulation interact or overlap in any way with the Canadian Treasury Board's requirements for algorithmic impact assessments to be conducted by vendors selling systems to the Canadian government? And then the follow-up directly to that is like, would vendors selling facial recognition systems to the government be then required to conduct assessments per that requirement? These are very specific questions and very good questions. This audience is all sorts of wonkery here.
I think it's very unclear in the legislation as written. The only thing that is clear is that it doesn't apply to the Ministry of National Defense and other security-related agencies. So that's the only clear thing, and it's unfortunate. I do believe that provisions should be made in order to clarify the obligations of public agencies.
Also, it exempts those who create products for those agencies too. So
then presumably no, then, right? Yeah.
Yeah. Well, yeah. That's why I'm here.
Yeah.
Yeah. So basically, and there are a lot of obviously companies that are, are related to the government, and so also I believe immigration is also one of the departments left out. So really, there's really very little in terms of accountability from within government, and I don't see, it's not clear that will ever be addressed. And it sounds like this is a bill to signal to industry, yeah, we're listening. Yes, we're doing this now. You've asked for it. We're doing this. We're setting something up that is very industry friendly. Because I don't know, maybe it's me, but self-reporting never works. I think that's just common sense at this point. So the idea that we're going to get companies to self-report, number one. Number two, that those reports are going to be consistent in terms of what they show and what they're looking for, I think is really sleeping in the clouds, to be honest.
There's another sort of similar question, but it's worth putting to the group here. The providers of AI services are not bound to use these services in the same way designers have set as intended to be used, are they? And then if that is the case, then how do you see the regulation of off-label uses of AI systems? Ignacio, you nodded, so I'm going to pick on you.
Okay.
Yeah.
I mean, that ties to what I was trying to say at the beginning, that this should not be regulating a technology. It should be regulating uses of a technology, because some uses are highly dangerous. Some uses, like the ones that Erica was describing in terms of profiling for the police, we know very well the harms that they can create. And there could be new uses later that we have not anticipated that create other harms. And so yeah, I do think that it's a problem. I don't have a solution for that.
There's another question here, and the panel sort of touched on it, but it's worth putting again explicitly. Like, can the new emerging audit industry be truly independent, and like, what is ICID's role in all of this?
Maybe I'll jump in here. I think. I think this is where we need some clear criteria in either the act or regulations. At the current form, I think we should be expecting that, and there should be discussions on how assessments, how audits are conducted, who conducts them, what's the criteria, what's the accreditation process, and what's the supervision of these conformity assessment bodies, as they're known in Canada, by the AI and Data Commissioner. So this is a key. If you're going to rely, as Emily was describing, if you're going to rely on incentivizing better self-regulation through a piece of legislation, you're going to have some pretty clear oversight, public oversight of this kind of private regulatory ecosystem. So I think that's really critical, both for assessments to help businesses understand how to categorize, or maybe have others categorize the risk level of the systems for them, and then also to ensure that audits, which is kind of heavily relied upon in the Act as one of the oversight mechanisms, accountability mechanisms, is trustworthy. So I think that's going to be a pretty key area for the evolution of this Act, its regulations, and for an audit. Let's say the UK is calling it an assurance ecosystem, whatever you want to call it, something to have a trustworthy, accountable ecosystem that for which with robust public oversight.
I'm going to put one. Oh, sorry. Go ahead. Somebody was.
I was just going to say, I think Erica brings up a really good point about self-reporting, and you could imagine there's some type of regulatory innovation or conversation on regulatory innovation that I'd be really interested in seeing evolve as the AIDA discussions continue, which is there seems to be there could be a bit of a gap between what is feasible given the scale of systems, how many there are out there in the private sector, and the feasibility or the meaning, the effectiveness of any self-reporting to a regulatory body. And I'm just going to say this, and need to think more about it. But as we think about assessment and auditing, there may be a need at some point for some type of intermediary layer for regulators to access in a timely way certain information about different systems while respecting confidentiality and proprietary technology. But there needs to be there probably should be a conversation about some greater need for regulatory agility. So we're not just relying on maybe point in time reports that are at a certain scale impossible to deal with, or only this kind of private ecosystem, which I think can be effective, but it could be interesting as we look at the multiple types of digital systems that are now interacting. There's maybe a need for some type of regulatory innovation on something that is a little bit more agile for governments, and I hope that was clear enough. But it's still a bit of a half-baked idea.
Can I just jump in with one?
Yeah. Go ahead.
We're running out of time, so I'll make it very short. But yeah, Philip, I agree with what you're saying. One thing I want to add is that I think that we should really realize too that we're in an experimental phase with trying to develop both, the auditing systems in this area and even in online safety, what good transparency reporting looks like, et cetera, because, if we even think of the example of Clearview AI, I mean, how, we could clearly see in the context of policing, and we know the harms that are associated with it, but there's all kinds of uses of AI that, how do we audit and assess for systemic risk, right? We need to build that kind of expertise, and that isn't necessarily there. And how do we then regulate it in particular? Like, so for example, Clearview AI, I mean, my understanding is that this was also a technology that could be used to find, say, missing children. So it had this like profoundly harmful effect, but also had, some positive uses. So how do we navigate that? And what is the role of, like, how effective is auditing in being able to unpack some of these layers? And I think that right now we're not certain.
That brings us pretty much to time, folks. Thank you so much to everyone for taking the time out of their busy day to watch the panel participants, Ignacio, Fenwick, Phil, Christelle, Emily, and Erica. This has been just a real treat for me. I learned a lot. I'm sure our folks did as well. We'll be posting this to the center's website when this goes up, and it will also be tweeting out the link once that is done. So thank you to all, and have a good rest of your day.
Thanks, everyone.
Bye.
Bye.
Everyone. Bye.